Hello everyone and welcome back. And if you're new to our channel, then welcome and we hope you find something useful. Today we're starting with a new series on our channel, that is a series on dying declaration. In the upcoming weeks, we'll be dealing with various aspects of dying declaration, including the basics, types of dying declarations, evidentiary value, and case laws. So stay tuned. Dying declaration is a hot topic from Indian Evidence Act which remains relevant whether you're a student, an advocate, a competitive exam aspirant, or just looking to gain some quick knowledge. Before getting into the essentials and the complex cases, today we will be discussing the basics of dying declaration. So let's start with the law which deals with dying declaration. Section 32 Clause 1 of the Indian Evidence Act deals with dying declarations, and it goes on to say that cases in which the statement of a relevant fact by a person who is dead or cannot be found is relevant in the following cases, and goes on to state the conditions for the same. So let's go on and read clause 1. When the statement is made by a person as to the cause of his death or as to the circumstances of the transaction which resulted in his death, then the statement is relevant under section 32 clause 1. So as you can see, it differentiates the dying declarations into two types. When the statement is made by a person as to the cause of his death or as to the circumstances of the transaction leading to his death, then the statement becomes relevant under section 32 clause 1. What each of these two types of dying declarations mean in detail, we will discuss in upcoming videos, but for today just understand that these are the two types of dying declarations mentioned in section 32 clause 1. Thus, if a statement of a dead person relates to the above two scenarios of the cause of his death or the circumstances of the transaction leading to his death, it will fall into the category of dying declaration. Moving on to the next topic, whether expectancy of death is required. The answer to that can also be found in section 32 clause 1, which goes on to say that such statements are relevant whether the person who made them was or was not at the time they were made under expectation of death. And thus we can conclude that expectation of death is not essential under section 32 clause 1. However, it is interesting to note that in England it is the opposite, and a person has to be under expectation of death for his statement to be relevant as a dying declaration. But in India, expectancy of death is not essential to fall under the category of dying declaration. Since in England a person has to be under expectation of death, there is more significance attached to the principle of nemo mortuoris presumptor mentri. And if I butchered that, I'm sorry, my Latin is not very fluent, but you can see the Latin maxim on the screen right now. This maxim basically means that no one will meet his maker with a lie in his mouth, and that it should be presumed that the person who's making the statement at the time of his death is not lying. And this maxim has much more significance in England because they expect a dying declaration to be made by a person who's expecting death. Moving further, what are the types of proceedings in which dying declaration can be relevant? The answer to this again can be found in section 32 clause 1, which states, and whatever may be the nature of proceedings in which the cause of his death comes into question. This means that dying declaration may be utilized in civil as well as criminal proceedings and is not limited to only criminal proceedings. Lastly, the basis of relevancy of dying declaration. It is important to note that dying declaration would not have been relevant under Indian Evidence Act because it would have fallen in the category of hearsay evidence. But section 32 clause 1 carves out an exception and makes the dying declaration relevant. The dying declarations can be very strong evidence, and in some cases, when the circumstances are right, it can even be the sole ground for conviction. The reason for this is that there is a presumption that the person gave the statement spontaneously and without fabrication. And since cross-examination cannot be done after death, the doctrine of necessity requires dying declaration to be utilized as is. Today we have learned the basic essentials of dying declaration. the types of dying declaration provided under Section 32 Clause 1, whether expectancy of death is required under the Indian Evidence Act Section 32 Clause 1, the types of proceedings in which the dying declaration may be relevant, and the basis of the relevancy of dying declaration. For more on dying declaration, stay tuned for the next video.